Good afternoon and welcome back to our COVID-19 and Your Property Now webinar live, Agent Tenant Landlord Analysis with our special guests. Today we have on the show Antonia Mercorella, CEO of the REIQ. We have Russell Child from Yield Asset Managers, Ludovic Mahu from Belle Maison Realty, and the Josh and Jono Jones boys from Ray White TradeCoast Commercial. Guys, I just wanted to share my screen with you here. Let me just bring this up. Bear with me. Alrighty. So on today's show, we have Ludovic Mahu joining us. Now, Ludovic is a proud owner of Belle Maison Realty with his wife, Lisa, a fresh-faced agency that strives to raise the benchmark by delivering quality, diversity, and innovation to the Gold Coast property market. Ludovic successfully forged his real estate success by providing excellent quality customer services. He's been recognized as one of the top boutique real estate agencies on the Gold Coast. Ludovic and his team aim for the best for their clients, achieving excellent results in both property management and sales. Belle Maison Realty, your home, our passion. We're also joined today by Russell Child from Yield Asset Managers. As a property owner, investment property owner, and self-proclaimed renovator, Russell knows and understands what to look for when inspecting and maintaining your property. He provides you with detailed reports on current and future maintenance issues to ensure your property is always in top shape, so it attracts and retains the best tenants. Russell has worked in the real estate industry for a number of years, developing sales and property management strategies, as well as becoming a finance broker that enabled him to help investors with the total journey of finding, financing and managing their investment properties. He says, as a property investor, you should expect a good yield from your investment without the inconvenience of having to manage yourself. We also have on today's show, Antonia Mercorella, CEO of the REIQ. Antonia is the powerhouse CEO of the Real Estate Institute of Queensland, REIQ. And as the REIQ's first female CEO and its youngest, Antonia has transformed the 100-year-old institute into one of the most progressive and high-profile real estate industry organisations in Australia. Antonia is committed to raising professionalism in the real estate sector and improving consumer perception of real estate practitioners. Antonia was recognised as one of the top 10 most influential people in Queensland real estate. She's also been profiled in Australia's Boss magazine and was named Queensland finalist in the Telstra Business Women Awards in 2018. Antonia is a solicitor by profession and has completed a Bachelor of Educational Theatre and Bachelor of Laws with honours from the University of Adelaide. Antonia's diverse work history has included roles with the State Theatre Company of South Australia and legal positions in both private practice and in-house roles. Prior to moving to Sunshine State, Antonia owned and ran a successful legal practice in her hometown of Adelaide. Outside of the REIQ, Antonia is also a board director of the Sycamore School, which is a school for children with autism. And finally, we'll be joined by Jonathon Jones and Josh Jones from Ray White Commercial TradeCoast. Just briefly, in 2009, Jonathon was given an opportunity to co-found the Ray White Commercial TradeCoast office in conjunction with the directors of Ray White Commercial Bayside. Since TradeCoast office opened in 2009, John has been specialising in sales, leasing and property management of commercial, retail and industrial properties throughout the eastern corridor of Brisbane. Later in 2010, Josh Jones joined the Ray White Commercial TradeCoast team to head the Commercial Asset Management Division, and subsequently was appointed in 2012 as a director also. Having previously worked for Ray White Commercial Bayside and property development company Landmark Queensland, as well as having managed numerous restaurants in the hospitality industry, Josh prides himself on building strong customer relationships with both commercial landlords and tenants. Now today, the commercial management portfolio has grown to consist of over 250 mixed tenancies in the industrial, retail and medical sectors. So welcome guys. I wanted to go across to Antonia first and foremost. And again, thank you Antonia for joining the panel today. Much appreciated, and I understand you've got a busy schedule. So thank you for that. I also wanted to acknowledge that the changes that we are all now looking at in Queensland are part and parcel to do with a lot of the work that you've done over the last week or so, with talking about the Residential Tenancies Practices Guide. So, Antonia, are you there?
Thank you.
Hi, welcome to the show.
Thank you so much. Thanks for having me.
No, it's great to have you on board. So, Antonia, so obviously we know now that we have the Residential Tenancies Practice Guide. The one that I have, the copy I have, was a draft, but that has been passed over the weekend or late on Friday. So we are now obliged by this. And I've just got some points there that obviously everyone can see on the screen. So now these laws have been passed. What are the main critical points that you take out of this document?
Yeah, so the law commenced on Friday, late evening. The final stage in the legislative process was the gazetting of the regulation. And really what that does is it does establish the moratorium that our Prime Minister spoke about back on the 29th of March. What it does is it establishes a framework of various protections for tenants and owners if the tenancy is indeed COVID impacted, which I'll talk about in a moment. And so what it does is it effectively says that if the tenancy is COVID impacted, there's a couple of key protection measures that it triggers. First of all, it makes it clear that any tenancies that are COVID impacted cannot be terminated or evictions can't be affected if there are rental arrears. Secondly, it gives the tenant and landlord the ability to negotiate a reduced rent. And also it automatically extends any fixed term tenancy agreements that were due to end on the 29th of September or before that date. They automatically become extended to the 30th of September 2020, unless of course the parties agree on a different date. And then finally, also the tenant is afforded the protection of not being listed on a tenancy database if they fall into arrears during that COVID period. So what's really important to note about the framework is that in order to gain the protection of these measures, the tenancy does need to be COVID impacted, and there's a three-part test, if you like, to working out whether or not a tenancy is in fact deemed to be COVID impacted. So part one, there are 6 different grounds in total, and at least one of those needs to apply. And so if you can't get, if one of those 6 grounds don't apply, then effectively there's no point moving on to part 2 or 3. So the way that it works is one of the grounds in part 1 needs to be triggered, and then if you can get past that, you move on to part 2 and part 3. And part 2 and part 3 are the ones that have perhaps been spoken about most publicly. And part 2 is basically if the tenant has suffered a reduction of at least 25% reduction in income, or alternatively that due to COVID, the tenant would be paying more than 30% of their total income towards rent. So if that test is passed, if that threshold test is satisfied, then what this new framework says is that tenancy is COVID impacted, and then effectively it triggers those protection measures that I've just taken you through.
Okay, great. And so just a comment, I know you're pretty full on live with the Facebook posts and so forth. So I remember it might have been a week or 2 weeks ago, you were on there late, coming live to people, basically explaining the framework that had come out prior to these changes, and obviously, you know, your concern with it all, and how agents were going to deal with this, and you know, and it was probably more so structured to suit the tenant than obviously the owner. And I've seen a few comments online about this, and the fact that you know, most tenants probably think that you know, property owners are well off, and that's, I think, you know, it's not the right thing to be able to put out there, because you know, we've got a lot of investors, we've got a lot of mum and dad clients who have worked hard to obviously make their position in life to afford to buy property. So I think you know, what you've done, and again, hats off to you, well done, you know, for pushing the government and trying to get these things through. So yeah. Okay, yeah.
No, I was just going to say, I think it's really important to acknowledge that where we started was obviously of great concern to us, and I think where we've ended, I mean, you know, I've been saying it is imperfect. None of this is perfect, and it can't be. We're in a dreadful health crisis that none of us could have predicted or planned for. But I think where we've ended up with this framework is quite fair and reasonable. And in particular, you know, I just want to highlight to your listeners that we're just trying to really communicate this message as much as we can, that the initial framework, there was a suggestion that landlords, once they agreed to a rent reduction, it became a permanent rent reduction, and there would be a prohibition on landlords being able to go back and seek the repayment of any unpaid rent. But under this new framework, the parties have contractual freedom. So if a landlord's in a financial position to offer a permanent rental waiver, they can. But just to be really clear to everyone watching this webinar, what this framework also does is it allows the landlord and the tenant to come to an agreement that whilst the tenancy is COVID impacted, the tenant might be able to pay a lesser rent, but ultimately the landlord can ask and negotiate for the unpaid portion of the rent to be repaid at a later date. So it's really important that when you are negotiating those agreements and when you're reducing them into writing using the relevant form that the Residential Tenancies Authority has put out, make sure you're very clear on specifying what that rent reduction looks like, for how long does it apply, and how and when will the repayments of the unpaid portion of the rent, how's that to be dealt with. So really important to get all of that detail into that variation agreement.
Yeah, and I think that the other point there was that, again, a lot of tenants would have known that the landlords potentially had, from the bank's help, obviously the moratorium to not have to pay their loan repayments for 6 months. But the other side of the equation was that, yes, well, you know, those loans will continue on, and their 6-month payments will actually get added to the time of the loan. So unfortunately, the landlord owner is going to continue to have to pay these loan repayments after that 6-month period. But the tenancy was going to be basically, you know, null and void, so they wouldn't have to pay it. So that's given some more clarity on it all, which is good. And I think you've touched on a point there that that Russell is going to take us through later on. But again, we'll probably, when we cross live to the other guys, we'll get some live examples from what they're dealing with in their practices right now. So just on the next slide there, Antonia, so we're looking at a couple of points there. So new legislation, tenancy financial hardship application form. So can you take us through that, what's involved, and, you know, what do we need to be doing with them?
Sure. So really the first step should always be working out whether or not the tenancy is in fact COVID impacted. So just to be really clear about this, if the tenant cannot meet that threshold test and it's found that the tenancy is not COVID impacted when you've gone through those three questions, then the normal laws apply. The special protection measures that commenced on Friday don't have any application. So it's really important that that's the very first step that's taken. And that will mean that owners and property managers need to have that conversation, because of course what's happened is that some people have misunderstood how this moratorium actually works, and there is an assumption that all tenancies are in fact covered by these new protection measures, and that's not the case. So that's sort of really the very first test that needs to be established. But let's assume for the sake of this exercise that you've gone through those questions and the tenant has been able to establish that the tenancy is COVID impacted. Then what the next step is really for the parties to negotiate a new rent and to negotiate the extension of that tenancy agreement, which, as I've said, any fixed term tenancies become automatically extended to the 30th of September, unless of course you mutually agree otherwise. So to do this process, there's a form that the RTA, Residential Tenancies Authority, has put out. It's quite a straightforward form. It identifies the parties, and then it has an area that's about the old rent or the originally agreed rent, and then there's an area where you put in the new rent. But again, I just want to be really clear that in that document, there's then an area that's called special terms or special considerations. And that's where you would need to be clear, because if you just fill it out using the bare basics, where it just says old rent and new rent, and you leave it at that, then effectively you're not allowing yourself to go back or to seek a rent deferral and to seek the unpaid rent. So it's really important that you do specify what the new rent is, but equally that if your agreement says that that the higher amount is to be repaid at a later date, that's specifically written into that variation agreement. So I really can't stress the importance of that enough, and just making it really, really clear that both parties understand when that rent is to be repaid. Now, the question we keep getting is, when does it have to be repaid? And I can't answer that, because it really is on a case-by-case basis. It's left for the parties to negotiate. There's no specific formula. The parties have total contractual freedom. So you might negotiate that it's to be repaid in 3 months' time, or you might negotiate that it's not to be repaid for another 6 months, for argument's sake. And it really will depend on what the financial circumstances of both parties are. So that's important to understand. In terms of the process for giving notifications of the breach, this is quite different under this new framework. The normal processes that you would go through under the Residential Tenancies and Rooming Accommodation Act, they're put to bed, so to speak, for a while. They're in limbo during this moratorium process. So the right form to use is what's called a show cause notice. Again, it's a brand new form that was released last night, and it's available for free on the Residential Tenancies Authority website. And what that form is that once the tenant is at least 7 days in arrears, and that might mean they haven't paid rent at all, or it might mean that they've paid rent but it's of a lesser sum, then you get to give what's called a show cause notice. And once you give that document, what it does is it puts the tenant on notice that they haven't paid the rent, they haven't met their contractual obligation to pay the rent, and the tenant then has to do one of two things within 14 days. They either need to pay the rent that they're required to pay, or they need to put their hand up and say, I'm COVID impacted, therefore I get the protection of the new measures, of the new COVID laws, and then that's what triggers the negotiation process. So the beauty of that show cause notice is that if you have a tenant who perhaps isn't communicating with you, hasn't picked up the phone, hasn't dropped you an email, has stopped paying the rent, and you're sitting there thinking, well, what do I do? This is the right form to use to get things moving. And if that 14-day period passes and they don't either pay the rent or put their hand up to say, I'm COVID impacted, let's negotiate, then really after that, you can issue the normal Form 11, which lets them know that they're in breach. And then ultimately, when you follow that process through, you could ultimately get to a stage where you do actually issue a notice to leave. So there's quite a clear legislative process that needs to be followed, and it's all set out really well in the guide and in the new legislative framework.
So Antonia, so if the tenant has suffered excessive hardship because of COVID-19, then, you know, even if this sort of happens, then obviously they can't be evicted for that period of 6 months, right?
Well, that's right, but there's a couple of exceptions to that rule. So first of all, if you issued a notice, if you had issued a notice before the 29th of March, then that continues to have effect. And similarly, even if you issued a Form 12, a notice to leave, between the 29th of March and the 23rd of April, I think that was the Thursday date, I hope I've got that right, then again, that notice is still applicable. So really all of this commences from the Friday when the new laws came into effect. So it's a little bit of a technical thing, and if you're unsure, any property managers listening who are REIQ members, they should call us for advice. And of course, anyone else who's listening can also call the Residential Tenancies Authority for free advice too. So there's a couple of dates in there. But as a general rule, yes, from when these laws commenced, if people are not paying their rent, you generally cannot issue a notice to leave unless you've followed some specific steps beforehand, as I've just pointed out.
Okay, and it's interesting. I mean, obviously, there's a lot of people in dire circumstances. But I think the reality is that, you know, obviously we've all been in a lockdown position, so we haven't been able to go out. So, you know, if you start to think about the numbers, we're probably receiving more income now on Centrelink benefits than there were before. So the reality is if you're looking at the, you know, the non-payment of rent, the circumstances are really that, you know, most people should have the money to be able to pay the rent and continue. You know,
absolutely. Yeah, absolutely. So there's going to be, so just to be really clear, that's why it's really important that we're doing a webinar like this, because you're spot on. There will be some tenants who could potentially be actually financially better off than they were prior to COVID-19. Not all, but some will be. And also some won't meet that threshold test. They may be impacted by COVID-19, but not in a way that's sufficient enough. So really, that's why we're doing as much education as we can. Just to be really clear, these laws are not designed to protect every single tenancy in Queensland. They're only designed to protect the select few tenancies that are genuinely impacted by COVID-19. That's why that threshold test is really important. And if that threshold test is not met, then you can go ahead and follow the normal rules and issue the normal Form 11s and Form 12s the way that you normally would. It's only tenants who can establish that they are tenancy impacted who get the protection of these measures.
There's probably a lot of people out there listening as well who may potential managers. So probably a good time for a lot of those people to actually talk with property managers to get these documents and things right.
Absolutely. Yeah. Communication is key. Couldn't have said it better. Yeah.
I've got a comment here from one of the attendees as well. I think every investor that has a rental property owes the REIQ. Suggest we all get together and apply for REIQ non-real estate membership fees for at least this year. REIQ is funded by members, and many non-members have received the benefit for services members paid. So it's only fair. I think that's a brilliant comment. You know, and again, Antonia, it's been an awesome commitment that you've done and pushed through there with the government. So nice comment there. Also, there's a couple of comments just coming in from Ben. He's asking some commercial tenancy. So we'll talk about some commercial stuff at the end. I might add just that if anyone wants to ask any questions, feel free to throw them down in the chat, and I'll try and pick them up and ask away. Antonia, just a final question, I suppose. There's a question here: are there same rules for resi and commercial? I think the answer is no. They're different, obviously. But with the commercial space, they're testing that based on the JobKeeper payment. So if a business client is eligible for JobKeeper, obviously they'll have an enrolment form and they'll have information from the ATO that they can actually pass to the. Is there anything pipeline in the resi world? So if someone's got a JobKeeper payment or something, or
yeah. So first point I want to make is that the laws that were passed on Friday only apply to residential tenancies. And so I'll talk about commercial in a minute. And in terms of the documentation that you can ask for when you sit down to do that negotiation piece around residential tenancies, we've advocated very hard for landlords to be able to ask for documentation so that the tenant has to substantiate their financial, substantiate their request for a rent reduction. And so really you are allowed to ask for documentation that allows you to establish how that income has changed, what that drop in income looks like. And so there's not an exhaustive list of documents for me to recite, but basically you would have heard the Minister talking about property managers or owners are allowed to ask for the sorts of documents you ask for when a tenant is first applying for a tenancy. So all of those documents you ask for to ensure that they have the financial capacity to meet the financial obligations under the tenancy agreement, you can ask for all of those documents. And again, as we've explained to government, this isn't about owners and property managers wanting to be sticky beaks and intrude in people's business, but rather it's essential because what we have here is ultimately a contract between two parties. And if one party is saying, I actually need you to reduce my rent on account of my financial distress, what we're saying is, for me to be able to sit and conduct that negotiation and to make an informed decision about what's fair and reasonable, I need you to give me the documentation so that I can arrive at a logical conclusion. So that's sort of where it sits with residential tenancies. I know that different people have different views on formulas and things like that, but we actually argued against a formula. We think it's really important that it's left up to the parties to decide what's right and what that reduction should look like. And of course, the owner's position also needs to be taken into account, because just to your earlier point, you know, this perception that all owners, landlords are wealthy people with lots of cash at their disposal, that just doesn't match the reality. So that's why we argued against a formula. But ultimately, if the parties aren't able to reach an agreement, there is that safety net. They can go to mandated conciliation that's conducted by the Residential Tenancies Authority, and then you've got an independent party that's looking after that for you. And then again, even if that fails, ultimately you can go to QCAT. But can I just say to everyone watching this webinar, you really, tenants, owners, property managers who are watching, you know, I would strongly encourage you to try and reach an outcome directly with one another. The RTA and QCAT, we don't know how long you'll be waiting for to be able to utilise those processes, and it's not in anyone's interests to be waiting weeks, if not months, for that, because of course then the rent debt could accumulate and become really significant, which is not in anybody's interest. So I would really encourage people to be reasonable and to try and reach a good outcome as quickly as possible. And then just quickly coming back to commercial, that's hanging in limbo at the moment here in Queensland. What we do know is that there's a commercial code that has been agreed to by National Cabinet. And the idea is that that code is to be adopted in all states and territories, and some jurisdictions have started to move on incorporating that into their legislative framework. That has not happened yet in Queensland. What did happen is last Wednesday, Parliament did pass some legislation. A bill was passed to create the establishment of a small business commissioner. So that's happened, and the idea is that small business commissioner will assist small business owners with their leasing disputes. And similarly, what has happened is that what's called a head of power has been created, which then gives the Queensland government the ability to create new laws by way of regulation, but the actual regulation itself and the detail is yet to be developed. And so there's work happening behind the scenes for commercial leasing. So anyone watching who's in that commercial leasing space, and I don't want to steal any thunder, I know you're going to talk about this later on, but I would really be encouraging people to perhaps just in the interim be negotiating things on a short-term basis, because of course it's likely we'll end up with new legislation in the coming weeks. And so you just want to be careful about not locking yourself into something permanently unnecessarily until we know where the law stands in Queensland.
Okay, great advice there. There's a few other questions come through. Mark McKenzie's asked some questions about commercial property as well, so I'll leave that to Josh and Jonathon to answer later on. Question. All right, so if you negotiate a new amount these days, do they still have to pay, and how would you collect these payments?
For residential?
Yes, residential, I assume.
Okay. Yeah, okay. So once you've negotiated a new payment, what you have to do is put that in writing using the prescribed form that the RTA puts out. It's called an 18D. It's the it's a variation agreement, so make sure you put it in writing. And then after that, the tenant should just keep paying the way they always have. So if it's through a property manager, then the money will continue to go to that property manager, or if it's the owner, whatever the process is. So the normal manner of payment would apply. It's just that there's been a reduction in the rent.
Okay, cool. There's a question here as well. So someone's mentioned Friday evening there was a something on Channel 9 News saying that if an owner didn't agree, they would be fined $6,600. I'm assuming that's
no. So the way that it works is there are penalties under the legislation, absolutely. So if a tenancy is COVID impacted, then if the owner was to try and boot them or evict them or issue a Form 11, for example, or list them on a tenancy database, or whatever they might try and do, then potentially they're exposing themselves to a penalty. But if the owner and the tenant can't come to an agreement, then what they should do is either party can then ask RTA to conduct a conciliation. So that's the way that works. So that penalty is there to ensure that landlords aren't just ignoring the new legislative measures and saying, I don't care, I'm still going to go ahead and evict you. So you couldn't do that. You'd absolutely get penalised if you did that. And yeah, it is to the tune of about $6,600 or thereabouts. But it's not an immediate penalty just for failure to come to an agreement. There's a process there. That's why that safety net is there, because you might try and come to an agreement between yourselves and you just can't. And then really what the next step is that you make that application to go to the RTA.
Okay, cool. I've got a question from Rob Jones. So he's asked, real estate agents are taking on a lot of the burden of implementing all these reforms. What protections are in place so that landlord or tenants do not sue real estate agents or property managers when there's differing views between tenants and landlords? So I'm assuming, you know, it's an insurance question, but how should they go about that?
That's a really excellent question, and it's one we gave careful consideration to when we were negotiating this framework. So the beauty of the framework is that the property managers have to follow their clients' instructions, like that's the first point, but equally property managers also have to adhere to the law. And so this is now law. So even if you've got an owner saying, I don't care, I want you to go ahead and boot them, I want you to issue the Form 11 and then issue the Form 12, I don't care if they're COVID impacted, what the property manager needs to say is, I'm sorry, but actually that is the new law and I'm required to follow it, as are you. So the property manager will be given protection under this. The other thing I would say about that is what we've done we've created some template documentation for REIQ members. They should have received this on Friday evening. And if they haven't, they can get in touch with us about it. But there's a document we've created. One document goes to the tenant and one document goes to the landlord. And each of those documents explain to the tenant and to the landlord that this is the way the new laws work. Tenant, you tell me if you're COVID impacted, and if so, tell me what you can pay and give me all this financial information. And then similarly, there's a letter that goes to the landlord saying to the landlord, hey, these new laws have started. If a tenancy is COVID impacted, you can't evict, you have to negotiate, etc., etc. And then the form asks the landlord to give you instructions on that rent reduction and what they agree to. And then the property manager, having been through each of those processes, will then sit down and do that variation agreement that I've mentioned. So the property manager will not be liable. They won't be caught in the firing line. Clearly, there'll be some owners out there who aren't happy. So, I mean, property managers will probably cop an earful. That will happen. I'm not naive about that. But certainly there wouldn't be any legal liability provided that a property manager is following all the right rules as set out in the new legislative framework.
Okay, awesome. And what about, so part of the other question there was, any scope for agents or property managers to charge a small negotiation fee between the tenant and landlord to assist in funding their own business, because obviously, you know, if tenants are not paying their rent, property managers are not collecting their management fee, and therefore, you know, suffering, but they're still dealing with this consequences. So.
Absolutely. Yeah. I mean, look, property managers, you know, as always, they're the meat in the sandwich, right? I mean, I always say I take my hat off to property managers out there. This has been a particularly challenging time for them because, you know, up until Friday, we were all in the dark as to exactly what to do. So what I would say to property managers out there is you are entitled to ask for a fee for that rent negotiation. Obviously, it's something that sits outside the scope of what you would normally do. And of course, property managers, they will find that their commission is reduced anyway. If the rent goes down, usually property managers or real estate businesses are paid on a percentage of the rent collected. So it's a bit of a double hit for property managers. And of course, they're working harder than ever. So you could ask for a fee. What I would say about that is you have to negotiate that with your owner beforehand. And it would be a variation to the Form 6, the appointment form that property managers have with their clients. But I would say to you, absolutely, you are entitled to do that. But look, you're going to find that different real estate businesses will approach that in different ways. Some real estate businesses wouldn't want to risk it. They'll be afraid to do that, you know, for fear that maybe the owner will tell them where to stick it and they might terminate their services. But I think it's all in the way that you ask, right? There's nothing wrong with saying, hey, look, this is a fair bit of extra work for me. And I'd like to charge a fee for it, and let's talk about what that is. So you can absolutely do that. But what's important is under the Property Occupations Act, any fees that you charge must be in writing, and you must be really clear about what you're charging for it and when that's to be paid. So it's just going back to those bare basics of what all property managers need to remember about the Form 6 process that they need to follow.
All right, beautiful. Thanks for that. So just one final thing before I touch over to Ludovic. Anyone out there that wants to buy a membership or subscribe to REIQ, how do they go about doing that?
Oh, thank you. That's lovely. So we do allow, obviously, predominantly our membership is for real estate agents. We offer both individual membership and agency membership. And then even for people listening who are not real estate agents but have an interest in keeping up with real estate, we offer something called affiliate membership. And I should have been better prepared to have the phone number ready for you, but it's 1300 my REIQ is the number to call. And the friendly team here can help you with that process. But thank you. Thanks for the opportunity to plug that. We appreciate it.
No, you're welcome. And I mean, the details will be out at the end of the webinar. So again, yeah, encourage people to get in touch with Antonia. Thanks very much for joining us. Stay on the line. I think there might be some other questions come through. So I'll just switch over now to Ludovic. Ludovic, you there, mate?
Yes, I'm in.
Oh, we got him. There he is. Okay, welcome, Ludovic, mate. So it's been a crazy ride. I know in the last couple of weeks you've been affected, obviously, by what's going on in the marketplace. But you've established your business down the coast there, down at Mermaid Beach, Belle Maison Realty. So do you want to give us a sort of heads up on what you were experiencing, I suppose, just before COVID came in, and then now what's happening since COVID's been on your doorstep, basically?
Firstly, thank you, Michele, for inviting us, and thank you, Antonia, for great work with the REIQ. I've been following all your video on Facebook, and very helpful for the industry, and bravo to the REIQ team for that. Before the COVID-19, the business in the Gold Coast was actually very good. We actually been very positive. It was growing the sale. The rental market was in very good, healthy, if I can say that words, environment and growth. Then the COVID-19 come up. We've seen a bit of a negativity coming around, but I think the industry himself tried to bounce with some more positive in general term. We have to adapt our method of working to ensure we protecting our staff firstly, and as well as our tenant and in general term. Then we have in this during the COVID-19, what we're seeing in the rental market on the Gold Coast is an influx of holiday letting. Obviously, that have an impact a little bit on the permanent rental. Even if these holiday letting are mainly fully furnished property and only for a short term of period of time, then this is, what's happening is we just have to adjust our rental. And when we talk to our landlord, if property haven't been renting yet, we just have to reduce and adapt to the market. Even if we only do a 6 months rent, and some good things come from that. We have tenant coming with say, well, the process, it's pretty difficult for the moment, and we will be prepared to pay 6 months in advance at a reduced rate. And we did accept that because I think it's a good security for the owner to get his rent paid for 6 months during that period of time.
But are you finding, Ludovic, that most people are, most prospective tenants are trying to negotiate quite heavily on the actual advertised rental amount?
In first, yes. We have a period of time for the first 2 or 3 weeks where my wife runs the property management and I have to come and help her because obviously we're being really, really bombarded by tenants want to reduce rent. And the first thing they were asking, some of them decide to not pay any rent. The usual suspect, I would say, the one they already sometime a bit in trouble. Then we managed that situation very well. But then what we did, we actually didn't sign anything until we have a proper information from the REIQ. Then for the first, some landlord decide to give straight away a 25% discount. And we did this for a 3 weeks period of time with a review every 3 weeks. Some of them, they said, listen, is no really things done yet. We try to get the tenant to still paying their rent, until we have a proper system in place. And now we have something that we can judge, we can make decision following a guideline is being really helpful because until now we didn't have any guideline. Yeah.
So and I think it's important to stay positive. Obviously, look, again, everyone in business today are in the same position dealing with this. And I think it's about the opportunity on the other side, how you come out of it. So no, that's good work. So I wanted to ask a question then, a question we've got listed on the slide there about property inspections and evictions and how you guys are actually handling that at the moment in your business.
Then we adapt actually quite very well. The first things I did is start to do some video of the property we were renting with. I actually put some video a little bit with some funky music, and then I decided to have what we call a 3-day virtual tours. A lot of company now come with some very good pricing and reduce this video, and they're fantastic because you can actually use them for an open home. You can for showing to properties to tenants. You can use them as well for your inspection. I'm just coming with an idea to purchase one of these 3-day video, and if the tenant was not confident for us to be inside, then we can just put the video in it. One person can be there and install it. Or the other way we've been doing is using FaceTime with some tenant that we trust. We know the property is always being well maintained, and we FaceTime with them and ask them to do a tour of the house with us. And the other one is, of course, is to delay the inspection. If someone is not prepared, was not really wanted us to come through, we just have an open communication and reschedule the inspection within 2 weeks or 3 weeks time. Of course, we keep our owner aware of the situation and let them know. Most of the landlord has been really good. They've been very cooperative with us doing this. Everyone think it's been understanding the fact that COVID-19 was a very serious health issues, and everyone wants to be protected against it. Then, in meantime, we adapt, the real estate industry is being adapting very well, I believe.
Okay, cool. And then obviously a question there with the tenant being infected by COVID-19, then I'm not sure if you can answer that. It might be an answer from Antonia, but so if the actual tenant themselves are infected with COVID-19 and you guys want to do a property inspection, what's the protocol there?
Well, if firstly, I will be honest, I wouldn't go to a property if someone's got COVID-19. That's my first, as a duty of care, I need to ensure my staff is protected. And protecting our community is very important. Then that's our first call. I know, and Antonia can probably reply to that, but I believe the REIQ was working with a cleaning company to work through the after COVID-19 infection process. And that's something Antonia can answer because I don't have this answer yet, but I'm sure Antonia can take on to that one.
Okay. Antonia, are you still there?
Yes, yes, I am. Can you still see me?
Yes, we can see you. Yep.
Oh, good. All right. I've managed to get to a different screen somehow, but I don't want to touch any buttons.
No, all good, all good.
So, look, that's an excellent question. So we, again, negotiated really hard to ensure that entry provisions were still contained in the Act, in the temporary provisions. So, but one of the grounds for that a tenant can rely on to say no to entry is if they are infected with COVID. And of course, you don't want to be going into a property where that's the case, A, because of the safety of people within the home, but B, for your own safety and the safety of the property manager and anyone you're bringing with you. So I would absolutely say to you that what you should be doing is asking certain questions before entry takes place. And if they're COVID affected, then don't go there, clearly for at least the 14 days. And then, yes, probably it's advisable to have that property cleaned to the new COVID standard. And this has been a tricky one because, of course, most of our time has been spent on meth lab cleaning, and COVID cleaning is now the new on-trend issue, dare I say. But there are now a number of cleaning companies out there who are offering cleaning services that are appropriate to make the property safe after COVID-19. But you would want to wait until all parties within the home have been quarantined for, I think it's at least 14 days. You'd want to get some specific medical advice on that issue before you even dream of going back into that property again.
And Antonia, the situation with the tenant, I mean, obviously, like if they were infected, what is the stance from obviously the property manager's perspective? Are they need to get something in writing from the doctor to say they're infected? I mean, look, it's easy for anyone to just ring up and say, oh yeah, I'm infected by COVID-19.
Yeah, this is dealt with really well in the regulation. It's got a list of grounds that if one of those applies, the tenant can rely on them and say, no, I'm going to deny entry on those grounds. And then, yes, the relevant evidentiary requirement is necessary. But if they're COVID impacted, usually a doctor's certificate or a certificate from the hospital will suffice. But you really, I mean, look, even if you've got a tenant who's saying, I'm not going to give you the evidence, I know it's a tricky one, but I would not be taking that risk. You would not want to go into that property. And I think, again, we've produced some documentation. If in the event that you've got an owner who's saying, well, I don't care, I still want you to go in, you really can't go in, because at the end of the day, there's a list of reasons or a list of grounds that a tenant can rely on to deny entry. So first of all, you'd be potentially breaching the Residential Tenancies and Rooming Accommodation Act, so that would expose you to potential penalties. But of course, any real estate principals watching this need to be aware that they do have obligations to keep their staff, their workers safe. So you would not want to be sending anyone into a property where someone's saying there's a human being with COVID-19 in that property. That would be very, very unwise.
All right, that's great advice. Thanks very much, Antonia, for helping out there. Ludovic, anything else you wanted to sort of mention, or just conscious of time here, I wanted to move forward?
No, I think you know, we talk mainly, we cover these two subject well. You know, at the end, it's a time that probably has been quite challenging, but as I mentioned before, I think we all did very well. And as Antonia said, I think the health and safety of our staff as well as our tenant is very important. And that's our first priority as an agency anyway for us.
All right, awesome. Keep up the good work, Ludovic. Well done. Stay on the line. I'll just, we'll come back if we've got time permitting. Just wanted to cross now to live to Russell. Russell, are you there, mate?
Yeah, can you hear me well?
There we are, coming in loud and clear. Okay, so Russell, Yield Asset Managers. So this is a new company out there today. Obviously, at the start, I mentioned that you've had a long history residential sales and management and so forth. I think it was with Ray White back in the day as well. So what are you seeing at the moment? Obviously, being a new business coming into market and dealing with things. I mean, you're probably Brisbane based, right?
Yeah, Brisbane based, East Brisbane, focusing around there. And just firstly, thanks for the opportunity to come on here today. It's been certainly informative. Antonia, you're doing a fantastic job. I've been as well watching all your Facebook videos at night, so it's keeping us up to date with what's going on. So you're doing a great job. Yeah, well, I probably started this business a couple of weeks before this COVID bomb hit. So I've had to adapt. I haven't got an old way. I'm adapting to what a new way is. And I think it's looking at different ways to communicate with tenants and owners, and also trying to get new business. So as well as having a really good supply of Glen 20 in the car when you go into these places. So
that's cool. So have you had to use the Glen 20 many times?
As we go. So, but I think it's the key issue is communication and looking at what technology is out there. And there's plenty of technology out there. It's just, I guess, not all of us have had that really need for it in the past. So, the Zoom meetings, which you guys are doing really well at the moment, and doing, the Facebook live stuff for routines and talking to tenants, and that is all really relevant. And I think we're going to get really used to using that as time goes on, even though they say they're relaxing a few of these conditions over the next week or so.
No, well, I think, like I said, I've said it a few times that this virus is termed the innovation virus. I think a lot of people have probably woken up and realised the impact that the technology is having. So yeah, it's a big thing, and obviously, yes, you're feeling it. So that's good to see that you're taking the right positive steps. I wanted to ask a question though, just leading on from the discussion with Ludovic about property inspections and evictions. I think on the other side there is the risk to landlords due to the lack of routine inspections. So do you want to fill us in a bit more about that? What you mean by that?
Yeah, well, I think it's a huge risk if we're going to wait 6 months before we get into a property. Yes, we can look at different ways to look at the property through the Facebook live, through photos and that. But if you're not in there looking at those properties yourself and seeing where that maintenance potentially is, yes, we can do emergency maintenance if a hot water system or the power falls over or something like that, we can get in and do that. But that regular maintenance, and if it's the taps leaking and little things like that, can cause damage in cupboards and the likes over time if you're not picking that up. And sometimes some tenants are pretty good, but some of them you've got a bit of a blindness to that, and you probably potentially won't see that. So I think we need to be really the utopia is to get in the property in a safe environment, and over time I think we're going to be able to do that now by the way they're relaxing a few things, and I think tenants are going to be more accepted to doing that. But if they're not, I guess we've got to use the technology like in Zoom, Facebook and the likes. But I think the risk of not getting in and having a look or having a good look at the property is certainly there, I think.
Yeah, cool. I think the thing that concerns me too is that if tenants are going to take videos internally themselves, we need to have some sort of system to be able to verify the truth in it. Obviously, like, I mean, they could take a video today, doctor it, and then send it out later on, and you wouldn't know any wiser. So I suppose there's a little bit of issue around that to come. But okay, that's good information.
I think also driving past the property, I think we all know if you drive past, you can pick up if somebody's looking after the property from the outside as well as the inside. So putting your eyes on that, but as I say, getting inside, it's the way to go.
Okay, cool. All right, now, and I've got a question there as well, which again, not sure if you can fully answer it, and we might need Antonia to jump in, but the question about, can you recoup losses after the tenancy ends if reductions to rents are applied? I think we did touch on it briefly with Antonia talking about it before. So
I think that the message is
any sort of answers on that side of things.
It's about communication, and something Antonia said that it's an open book in terms of the communication or the agreement. It's an agreement between the two parties and the property manager in the middle, trying to facilitate that. And I guess it's from where I feel it's getting as much information as you can on both sides, so you can put put a clear picture in front of the owner and the tenant, and hopefully negotiate some sort of repayment down the track, and or spread that over the length of the lease or whatever that might be. But I think it's key that we document that. I haven't looked at this to a self-assessment tool yet, because it wasn't connecting when I tried to look at it before I came in here. So I'll be interested to see what that looks like, and I'm hoping it's a bit of a framework to help with that. Coming up, but I think communication's the key thing, and you know, I bring my finance broking days back in, and how that works, and how we can come up with a really good mutual beneficial agreement for all parties, that, because no one's going to be a winner. Let's face it, but make sure we come out of it. We both come out of it. I'm not sure if that's a fair take on that, Antonia.
Yeah, that's a good answer, Russell. So it's really up to the parties. You might decide that the unpaid rent gets paid back in instalments over a period of time, or you might decide that it gets paid in one lump sum by a certain date. And realistically, there's going to be, depending on how badly financially impacted the tenant is, it may be that you don't get paid back until after the tenancy agreement has ended. So all of those things are up for grabs, and it all comes down to really careful documentation, making sure you're really clear about all of that in that variation agreement.
I think what you said before about the RTA, none of us want to end up in there, because we know how long it can take. And if the tenant's not paying during that time, everybody's losing, the owner's losing, and you can't evict in that time frame if they're COVID affected. So you're better to come to some sort of resolution, in my view. Yeah.
All right, cool. Well, thanks for that, Russell. Thanks for your time, and good luck with the business, obviously starting out there in a crazy time, but best of luck to you. I'll stay on the line. I'm just going to jump over to the Jones brothers. So, boys, are you both there?
Yeah, we're here. Well, I'm here. Josh?
Okay. I thought I'd lost you.
Yeah, I'm here.
Josh is saying around. There he is. Okay, beautiful. So boys, thanks for coming on the show today. Again, much appreciated. With the commercial tenancy space, I think there's a few people online today that are thinking about how this affects them and so forth with their commercial properties. And I know Josh and I have spoken in the last couple of weeks about the fact of what most people are doing out there. There's a lot of sort of big players out there that are trying to take the mickey out of the whole situation as well. So I suppose, boys, do you want to just give us an idea about what you guys do in Commercial TradeCoast, how you operate, and then we'll get into these points.
Okay. Look, this is my 15th year of real estate. We opened the office I opened the office in 2009. Josh joined a year after, and we've been a member of the REIQ the whole time as well, Antonia. But we specialise in sales, leasing and property management of pretty much every asset class in commercial real estate, industrial, retail, medical and office. So yeah, it's certainly a challenging time at the moment, but we've been around long enough and seen some major challenges in our space before, GFC, the Banking Royal Commission. So this is just a completely different challenge now for us. So we've always seemed to get on the other side, and only gotten stronger.
Yeah, well, I think we'll all come out of this, obviously, but now we have to obviously just deal with another set of rules, and make sure that obviously the tenants are actually giving us the right information, telling the truth.
Right, yeah.
So look, the points I've got on the slide there, talking about relief, most of us hopefully by now know that the government announced these measures to help obviously renters. Most of it applies obviously to retail, office, industrial space, and I think those points, the outlines there, that they must be a small to medium-sized business with an annual turnover of up to 50 million. And most importantly there as well, eligible for the JobKeeper payment. Now, interestingly enough, after our last webinar last week, we've just been inundated with JobKeeper applications and calculations. So I think you guys obviously in your space with the commercial tenancy are probably going to feel the effect of that this coming week, with the fact that most people are now potentially enrolled. most people now will potentially get some sort of feedback from the ATO to say that they are, obviously been accepted and eligible. And then they'll probably be coming to you for guidance from that perspective to say that, their business has dropped off by 30%. So I suppose, Josh, is there anything that you can tell us, I suppose, that you're dealing with at the moment that's live, live cases? I know we spoke about, there are a couple of tenancies that had initially said to you that maybe they were not going to be able to pay the rent, and then they've changed their tune. What can you tell us? Can you give us some live examples?
Yeah, absolutely. So I think what's important as well is that, on April 3rd, when the National Cabinet released this mandatory code of conduct, I think that all tenants just simply saw the announcement and thought, okay, well, there's a ban on evictions for 6 months. This applies to me. And all of a sudden, within the next sort of 24 to 48 hours, I just got a massive influx of emails from tenants across the board, just with emails saying things like, Josh, I've just, we're down 80% in our revenue. That means that you have to give us, an 80% reduction in rent. The amount of emails like that were absolutely ridiculous, to be honest. But what I've seen now as well is that, what needs to be important, like residential as well, is that this code of conduct doesn't apply just straight up for all tenants. As suggested, you have to be a medium to small business with an annual turnover of up to 50 million and eligible for the JobKeeper payment as well. So with the JobKeeper initiative, where all of those financials could actually be submitted to the ATO as of last Monday, one of the interesting things that I actually did see is that last week we probably had about 10 to 15 withdrawals of rent relief requests across the board. Some of those being, quite large national tenants, which I won't mention their names or anything like that. But it is interesting because one of the key words in the mandatory code of conduct is that this is a good faith leasing principle set of guidelines as well. Everything has to be done on good faith. One of the other terms that we need to use in order to facilitate these rent requests is that we need to be provided with sufficient and accurate information. So all of a sudden, when we have been asking for the financials for a lot of businesses, it is quite interesting to see that some of these rent relief requests have simply been withdrawn as well. So that's one of the more interesting things that I've seen in the last 7 days. When you are pushing for accurate and sufficient information for these businesses, some of them have simply withdrawn their requests. So it is disappointing to see that some people are using this to their advantage to potentially make more money than ever. But I have actually had a few requests as well of businesses even over the weekend that have sent me an email and said, Josh, look, we're actually looking to open up our business over the weekend as well. One of them being a hairdresser, and simply sent me an email saying, we will now withdraw our request. We'll pay your full rent in May as well. We're back on our feet, but we'll let you know if the situation changes as well. So there's a lot of good, honest people out there as well. But there have been a lot of people that have been trying to use this to their advantage. But in saying that as well, that the market and the economic conditions, a lot of businesses are in financial trouble. And those are the businesses that have been willing to, put that information out there. But I think a lot of that financial information will start to be received over the sort of, the next week or so. Because what I'm finding is that the April period, out of, all of the months that have just gone by is probably the one where revenue figures and reported figures are going to look the worst. And that's a period in which I think most businesses have found it the toughest. And we have to get through that April period in order for them to actually report those figures.
Yeah, so it's such. We run a mini economy in our office here, and most of the JobKeeper payments we've basically applied for have been for that April period. So it's interesting. There are a few different tests that you can test to get this JobKeeper payment, and the government came out with the alternative test last week as well, which pretty much now has opened up a bigger scope for people to access it. So I think what's interesting from my perspective is that a lot of people will probably qualify for JobKeeper payment for that April period, but then what you'll find is that going back into business they'll probably generate more income in that May, June, July period, even though they're still entitled and getting the JobKeeper fund. So it's going to be interesting how they sort of, mandate that against obviously the tenancy side of things.
Yeah, absolutely. So, well, one of the toughest things that we've got at the moment is obviously getting all of the requests that we've had. We've had varied approaches as well, in which has worked for some businesses with providing rent relief and, implementing the principle of proportionality, all that sort of thing as well. But unfortunately, there is still a large amount of the requests that haven't been able to reach an agreement as of yet. And unfortunately, that has all stemmed from, we do have this mandatory code of conduct, but in Queensland, as Antonia was saying, it hasn't been regulated as of yet. So there is a large amount of these requests that landlords and tenants alike just simply haven't been able to reach an agreement. And from that, most people are actually just sitting here and waiting, and hopefully that we'll have some more indication this week as to the regulations and actually implementing it as legislation, because there are so many of these requests that are just at a standstill simply because there can't be an agreement reached between a landlord and a tenant. So we are hoping once that has been regulated, we will be able to start implementing a lot more of these requests.
Yeah, so I think we need to stress that obviously this mandatory code of conduct is there, but we're still waiting on more information to come from government. There's a question here from a Mark on the chat here. So the question to Antonia, Jonathon and Josh: in the commercial tenancy space, what is the definition of turnover when assessing a tenancy for COVID impact, in particular for a childcare centre where the government has guaranteed 50% of previous turnover, plus the JobKeeper stimulus and also the cash boost? Can we as landlords include all of these when assessing their turnover?
I think from my perspective as well, like that's one of the things that does need to, for regulation to come into place, because in the principle of proportionality, they actually sort of mix up their words a little bit as well in the formula, where they often refer to turnover and then, on the next sentence, they'll, refer to revenue. So there's a bit of a discrepancy there as well. We don't manage any childcare centres ourselves in the office at this point. But I also think from that side of things that, look, if the government's going to step in and provide 50% of their revenue, then that should certainly be taken into consideration for rent relief as well. I think the JobKeeper payment, however, is probably a separate question as well, because you do still have businesses out there at this point in time that are 100% locked down and 100% of revenue, 100% of turnover lost. So some of those businesses are eligible for JobKeeper, and it might be more of an accounting question, to be honest, Michele, and to say, well, if they get a lump sum payment from the government as of next week, will that go from 100% revenue loss to all of a sudden having 5% or whatever revenue back in simply because they've received these JobKeeper payments? So I think they're two separate questions, if I'm being honest.
Yeah, correct. So obviously from my perspective, and we looked after a fair few childcare centres. So in that case, yes, they are reduced and they are entitled to the JobKeeper payment. So I would assume that the assessment would go through and flow through to the commercial side of it as well. Out of the client base that we have, majority of the childcare centres, however, own their own properties. So it's a little bit hard to answer that question, not dealing with a landlord when the landlord is themselves. But I would assume, yes, on a JobKeeper, if they're able to claim the JobKeeper payment, yes, they would be potentially able to go and attack in that space. So yeah. Yeah,
and I think it's one of these things that we haven't crossed that bridge as of yet, simply because the JobKeeper payments haven't come through. So the revenue figures and the financials that we have received as of yet, those payments haven't been received. So it's something that we are going to have to obviously tackle in the next couple of weeks once they start coming through.
Yeah, I mean, it's yeah.
Sorry, I might just jump in there and say that that's an excellent question about what constitutes turnover. It is very confusing. The code doesn't address that properly. That's one of the things that we're seeking clarification on. I imagine that any government relief or grants should be included. That's been the position taken with the residential tenancies framework. When assessing income, you have to include payments like JobKeeper, JobSeeker, etc. So I can't imagine that they take a different position in the commercial tenancy space, but they're all excellent questions that are yet to be properly answered.
I think it's similar in the JobKeeper world as well, because they talk about GST turnover for most businesses, and the reality is that you might have a small sole trader who's less than $75,000 turnover, and they don't need to be registered for GST. So again, there's ambiguity with the wording in the legislation, and I dare say it'll flow out into the commercial space as well. So Josh, just another question there. I think it's all about, again, the assessing the group level. So when defining a small medium enterprise, the code seems to suggest retail groups are assessed at the group level. However, we've found at least one national group wants us to assess their rent abatement request based solely on their Queensland figures. Can they demand to see their national figures?
That's the other problem that I'm having with some of these national tenants as well, is they're very reluctant to give me their financial information. My advice is that, look, the code of conduct is pretty clear, in that they have to provide us with, sufficient and accurate information to be provided. I think what they have to realise as well is that we're here to help as well. We're here to facilitate those requests. And in order for us to actually fall in line with the code as well, we can't do that unless we see the financials. I think the same would apply. And, if it is at a Queensland level, it would be the same as basically like a franchisee, I would think. We're assessing all franchisees as an individual basis, not, as the group as a whole. And we're doing those by store financials as well. I think if they do want the help, and we do want to implement the principle of proportionality, they have to be open and honest and willing to give the financials, whether that's Queensland or national level.
Yeah, I couldn't agree more. I think that's exactly right. All right, cool. So my final question to you, I suppose, is that from a negotiation point of view, would you suggest that it's better, if you do have a commercial tenancy agreement in place, and obviously you come to terms that they can't pay the rent for 6 months, that you will renegotiate the lease term and add that 6 months on to the balance of the lease? Or
that's definitely one approach that we've had so far, and it has been successful as well. With the guidelines, basically with this 6 month period, what it is suggesting is that, say if this period does go for 6 months, then 50% of that is seen as a rental waiver completely, so rent free. And the other 50% is a rental deferment that is to be paid back over the life of the lease, or over 24 months, whichever there is the greater. So, but what I am finding as well is that a lot of tenants, places like gyms I've found have been the best to negotiate with, where they have simply said, look, we don't need that sort of incentive. We want to do what's right by our landlords. And we have come to agreements where we would simply add whatever months we're going through now that they can't pay rent to the end of their lease, because the guidelines are pretty specific in saying, look, if you can come to an agreement outside of these guidelines, then that's absolutely okay as well. So, some people have been able to reach those sort of agreements, and at this point in time, we haven't locked down things like implementing deed of agreements for those, because we just simply don't know how long they're going to be locked down for. But we do have an agreement in place to say, well, if it goes for 3 months, we will add 3 months to the end of their lease. And for them, the majority of those people as well is because they do have a lease term that expires before 24 months time as well. So, to have a payment plan over 24 months, they've just simply said, look, just add 3 months, 4 months, 6 months to the end of my lease agreement, and we'll do a deed of extension when the time comes that we know when we're going to be open again. So, but there are varying degrees of other agreements that have been reached as well. One of the more successful I've seen in the retail space with sort of smaller shopping centres is that landlords have actually given the opportunity to tenants to pay their rental 1 month in arrears. And what they've asked for is their sales figures at the end of each month provided by the 5th of the following month. That way they're basically saying, look, we're going to take this on a month-by-month basis to see how bad this gets, or when things open up again. So on the 5th of the month, everyone provides their financials. They do the principle of proportionality accordingly. And then for that month that have just gone, they reissue an invoice. And then at the end of the next month, they'll do the same thing. So they basically just take it on a month-by-month basis at the moment and a case-by-case basis. So there's a lot of different approaches that are being successful at the moment. But there's also a lot of, the majority of the tenants that, especially in this full 100% lockdown, we've only managed to agree, 2 or 3 of these particular tenancies with actual agreements until this is legislated.
Yeah, cool. All right. Final questions come in from one of the panelists, Ben. It says, if my commercial tenant has stopped paying, can I issue notice of breach and load up legal costs to pass on to them?
It just depends if they fall under the JobKeeper initiative. So, one of the other things that the guideline is pretty clear about is that tenants remain committed to the terms of their lease unless this has been superseded by one of the guidelines. If they don't fall under, the commercial code of conduct and they're not eligible for this, it's not a free ride for them. So from that perspective, it does still need to be regulated, but we would act as normal because one of the guidelines is tenants remain committed to the terms of their lease agreement. This is where tenants really need to be aware that, it's not a free ride for 6 months. You have to meet certain criteria as well, one of them being the JobKeeper initiative. And if you don't pay your rent, then, normal circumstances should apply. That's one of the things as well I'm seeing at the moment is that I think, first and foremost, that they have to be aware that they have to start the conversation with people like us as well. They need to start speaking. I know that there has been some situations as well where landlords have taken quite a long time to respond as well, which makes our life difficult. But they need to start that conversation. They can't just bury their heads in the sand and think that they're going to get a 6-month ride on free rent. Yeah,
no, that's cool. Great advice, mate. And like I said, anyone out there that needs help, make sure you got the right people, the boys there in the commercial space. Negotiations most important. So, make sure you've got well informed. All right. So I wanted to call it there. I wanted to thank, obviously, today, everyone for being on the panel. Ludovic from Belle Maison, Antonia from the REIQ, Josh and Jono Jones, Ray White Commercial TradeCoast, and Russell Child from Yield Asset Managers. Guys, thanks for your attendance. Thank you for those online listening in. As always, appreciate your time and your comments. Again, follow us on Facebook and Instagram. Subscribe to our YouTube channels and keep up to date with upcoming webinars as they get launched. And again, from all of us, stay safe, keep up the good work. Thank you, guys.